Hello, everyone. Welcome. Thanks again for joining us for this Skill in Demand Subclass 482 Visa webinar, where we'll unlock some key insights into the Skill in Demand Visa and also make some important sort of recommendations about transitioning to the 186 visa, and in particular in the temporary residence transitional stream. Right. Let's have a look at today's agenda. So basically, we'll have a little introduction about the Skill in Demand Visa, a bit of a recap of what we sort of discussed in the previous webinar. We'll also look at the eligibility requirements for the Skill in Demand Visa. Then we'll take a look at the pathways to transition to PR from the 482 visa. Again, the eligibility requirements, the application process. So stage one being employer nomination, and then also stage two being the visa application. Moreover, we'll look at how Questra can help. So early eligibility check is obviously first and foremost. Then obviously contact your employer. So the way I usually go about sort of tackle these sort of situations is I always recommend that the visa applicant consult with us or a registered migration agent for that matter, establish without any shadow of doubt their eligibility. And once you've established that eligibility, obviously you can then approach your employer because you'll have all the facts on your side, and that just becomes an easier conversation. If you approach your employer and you don't really understand or know that you're eligible, then it will be a different conversation. So just keep that in mind. Obviously then, once we've had sign-off from your employer as well, prepare and lodge the nomination on behalf of your employer and the visa on behalf of the visa applicant and, of course, if necessary, your dependents. Then we'll have a look at processing and common issues. So obviously, particularly those who are holders of a temporary skills shortage 482 visa. That visa is typically for a duration of 2 years. So we'll go through some do's and don'ts to make sure. And if you're a holder for short-term, a visa in the short-term stream, then particularly if you want to apply within the 2-year validity of your short-term visa, then you should be aware of some sort of common issues to avoid and how to sort of best combat that. If you're on a TSS visa, on the medium-term visa, then potentially you'd have a 3 or 4 year visa. So there's a bit more margin for error there. But nonetheless, I think the end game would be that everyone applies for 186 as early as possible, and any sort of mistakes or errors that are made to be corrected as early as possible. So everyone's situation obviously is unique. And everyone's set of circumstances different to one another. So that's why it's important sort of to get your circumstances assessed individually, so you can also receive the correct information and apply as early as possible. We'll also then round up with some frequently asked questions that our team has prepared. So obviously we get many inquiries. We've got a lot of clients who are on TSS visas, on short-term and medium-term stream. We've also got a lot of clients who have applied for the Skill in Demand visa. So we've got a bank of sort of common questions that we'll answer. And then if time permits, I'm also happy to take some of your questions as well and solve any queries or doubts that you may have regarding Skill in Demand visa and transitioning to PR. Please note that, it's difficult to talk about in a public forum individual sort of cases. So these answers will be of a generic nature. Obviously, if you want your individual circumstances assessed, then we do implore you to seek professional advice. We'd love to see you here at Questra Immigration, but be sure to seek professional advice regarding the intricacies of your unique circumstances. All right, so obviously anyone who is a holder of a 482 visa, either in the short-term stream or the medium-term stream, would be eligible for PR via the 186 TRT pathway. anyone who's a holder of a skill in demand visa or a prospective skill in demand visa applicant, so any future applicants of the skill in demand visa will be eligible for the 186 TRT pathway. And on top of that, any partners of skill in demand or temporary skills shortage visa holders or applicants, so partners of current or future skill in demand visa holders. So basically, you don't necessarily need to be included in the skill in demand or temporary skills shortage visa at any stage. When you are able to satisfy the de facto partnership requirements, you can apply as a subsequent entrant to be included in a skill in demand or TSS visa. Or if it's at a lateral stage and your partner is actually at the point where they're applying for 186 visa in the temporary residence stream, then you can also be included in a combined application, irrespective if you as a partner or dependent were a holder of a TSS or skill in demand visa. Obviously, at that stage, when you do the combined application, we will need to present a portfolio of partnership evidence. You'd either need to have been living together for at least 12 months, or register your relationship with births, deaths and marriages, or present a wedding certificate. Just on that, registration relationship certificate holds the same weight as a marriage certificate. It's a lot more, affordable and quicker, because if you are to marry, then obviously you need to complete a notice of intention of marriage, you need to wait 30 days, then you have to organise a celibate and whatnot. Whereas with a registration of your relationship with births, deaths and marriages registry, it's a couple of online forms, $260 odd, and you'll receive the certificate. And like I said, it holds the same weight as a marriage certificate for migration purposes. So just keep that in mind as well. All right, so recap of the last webinar, which primarily focused on the new skill in demand visa. So as everyone's aware, some of you were with us in the previous webinar. Some of you didn't have the opportunity, so I'll just do a little bit of a recap. So basically, the skill in demand visa was introduced on the 7th of December. Some positive sort of aspects to it, not so positive, so it just depends on your personal circumstances. New occupation list was also released, so CSOL list is an expanded list, no more medium-term stream or short-term stream. And basically, unlike before where you had to hold a medium-term stream visa to be able to apply for direct entry, now all skill in demand visas, provided your occupation is on the CSOL list, can apply for direct entry. And more attuned to today's webinar, all visa candidates can be granted skill in demand visa for up to 4 years. So it doesn't necessarily need to be 2 years for a short-term stream or up to 4 years for a medium-term stream. All visa skill in demand visa applicants will be granted a visa for up to 4 years, right? So we typically do them for a duration of 3 years, because that gives you enough time with a little bit of sort of margin of error to be able to transition to PR successfully through the 186. Also reduces some of the overhead costs for your sponsor, because if it's for a 4-year visa, you obviously need to pay a SAF levy for 4 years each year. And if it's a 3-year visa, you only need to pay each year for 3 years up front. SAF levy is quite significant. So for a business which has a turnover of under 10 million, they'll have to pay $1,200 per year up front. So if it's a 3-year visa, they'll have to pay $3,600 up front when at time of nomination. If it's a large business, that means the turnover is more than 10 million, then the SAF levy is $1,800 per year. So sometimes this can be a little bit discouraging for your potential sponsor or employers. That's why we typically recommend a 3-year duration. Some employers are happy with a 4-year visa and happy to pay the SAF levy. Some insist on a 2-year. Obviously, if that's the instructions of the employer, we can certainly facilitate that. Obviously, you just need to be a bit more careful, and we'll have a look in the next slides of what some of the common issues are with the skill in demand visa in light of looking to transition to PR through the 186 TRT stream. But nonetheless, if you've got all the facts up front and empowered with the knowledge that you need, you can avoid making mistakes that, in the end of the day, I mean, even if it's a 2-year visa, worst case scenario, you'll have to, and for whatever reason, you aren't able to transition within 2 years, you'd have to apply for a new skill in demand visa, albeit for 1 year. And as soon as you fulfill the eligibility requirements of the 186 TRT, you'll be able to lodge the 186 visa. So as we saw, so some of the requirements, an overview of the skill in demand visa as per the last webinar. So need to have an occupation on the CSOL list, which is quite an expansive list. You need to have relevant qualification depending on the skill level. So if it's skill level 3, you need to have a certificate 3 or 4. An example would be a carpenter. If it's skill level 2, example would be a facilities manager. You'd need to have a diploma. And if it's skill level 1, example would be an industrial engineer. You need to have a bachelor degree plus 1 year work experience, right? So full-time, part-time equivalent. Now, in lieu of having a relevant qualification, if it's skill level 1, 2 and 3, you'd need to have 3 years full-time work experience or part-time equivalent. If it's skill level 1, you'd need to have 5 years full-time, part-time equivalent work experience to substitute the qualification. This has now become also a time of application criteria. So in the past, depending on someone's situation, we have lodged a temporary skilled shortage visa with someone having less than the 2 years work experience. That was a requirement previously. So it's now reduced to 1 because we knew that whilst their visa was processing, the nomination, sometimes SBS nomination on behalf of the business and the visa, we were able to accumulate work experience. And being a time of decision requirement, if they accumulated that 2 years work experience whilst their visa was still pending, then that satisfied the requirement. But now with the new skill in demand visa, although it's been reduced to 1 year, the work experience requirement, you need to have that work experience at time of application. So that's a significant sort of change. The English requirements 5.0 in each band, and obviously there's also health and character requirements that need to be satisfied. We've also got our teams been working tirelessly to keep up to date and to keep our clients and audience up to date regarding the new skill in demand visa. So we have got a 3-part blog series on our website, which also provides a detailed guide on the application process, eligibility requirements, processing times, and all that. So I would encourage all of you to have a look at those blogs because there's some really excellent information there for you to have a look at and keep yourself up to date and abreast of all the latest migration news regarding skill in demand visa and also the 186 TRT visa. So at this point in time, I'd like to encourage everyone, if you haven't signed up to our newsletter, please do. Like I said, the team's working tirelessly to provide blogs on a weekly, sometimes even more often basis. As you guys are aware, the migration industry is very dynamic, and the news flow, particularly since last year, has been very constant. So we do our best to keep ourselves up to date, first and foremost, and then obviously to keep our clients up to date as well. So please sign up to our newsletter if you already haven't. So, all right, so let's have a look also at the 186 TRT eligibility requirements, right? So first and foremost, you need to hold 482 visa for at least 24 months in the last 3 years. When we refer to 482 visa, we're typically talking retrospectively about the temporary skilled shortage visa, but the same will apply also for the 482 skill in demand visa as well. Also, you must have worked in your nominated occupation with 1 or more approved sponsors for 2 years in the last 3 years as a subclass 482 holder, and this directly refers to the primary visa holder, right? So typically speaking, for short-term visa holders, we're allowed to apply for TRT a couple of days before 482 visa expires, so a couple of days before the 2 years, and that's been confirmed by the policy department as well. So, for example, if someone's 482 visa in the short-term stream is expiring on Friday this week, we'd prepare and lodge both the nomination and the visa either Wednesday or Thursday. And even though they haven't, by the letter of the law, completed 2 years, the department allows for this concession, right? So, and we've done this successfully with many of our clients who were holding temporary skilled shortage 482 visas in the short-term stream for 2 years. We'll have a look at some common issues that could arise, right? But we have confirmation and we've had plenty of nominations and visas granted along those lines, right? So what are the stages of the 186 TRT visa? So unlike temporary skilled shortage visa, where there's 3 applications, standard business sponsorship, employer nomination and visa application, for 186, there's 2 stages. So the first application is lodged on behalf of your employer, which is a nomination application. This typically will entail various submissions about details about the business information, also genuine, so basically financial reports. So basically we evidence that the business has the capacity to pay for the nominated salary for the next 2 years, right? It also obviously offers a streamlined process, and we also utilise available information as required. The nomination can be lodged moving forward. The nominations can be lodged 1 or 2 months now prior to the visa application. Basically, what happened in the past, the payment requirement was typically linked to the nomination, whereas more recently, this aspect now has moved on to the visa application stage. So for that reason, we are able to lodge a nomination 1 or 2 months earlier than the visa application. In essence, I mean, it doesn't really matter because unless the visa applicant has fulfilled the 2 years, the case officer is not really going to look at the nomination either yet. So all things being equal, we usually lodge the nomination and the visa application simultaneously. The second stage is obviously the visa application, right? So obviously the visa application is submitted on behalf of the applicant and dependents. Obviously, we need to ensure that you meet all the requirements and guide you, the visa applicant, in preparing any missing information, right? We'll look at common issues in a few of the later slides to ascertain what you really should be looking at and what you should avoid. So how can Questra help in all this process? Obviously, you should get on the front foot, so seek advice as early as possible. That way we can mitigate any sort of risk of not being eligible as early as possible. We can guide you on preparation of documents and, as I said, ensure your eligibility as quick as possible, right? Because I'm sure everyone's sort of end game is to get permanent residency and then citizenship. The earlier your eligibility is confirmed, obviously the earlier we can apply, the earlier your visa will be approved, right? So that's the main thing. In terms of employer support, what typically happens with employer nomination or employer-sponsored visa, if it's an existing client, obviously we're in touch with your employer on a regular basis. If it's a new client, then we're also happy to, once we've confirmed your eligibility, and whether that's for the skill in demand visa or the 186 visa in either stream, temporary residence or direct entry, once we've confirmed your eligibility, we actually offer your employer a complimentary meeting to sort of convince them as well that this is a path that they should take, and also to get the ball rolling with your visa application. As we mentioned earlier, there's 2 aspects. Nomination relates to your employer, so you do need your employer's support, either for a skill in demand visa or the 186 in the TRT stream or direct entry stream. So without your employer's support, it's not possible to lodge either of these applications, right? So obviously, aside from that, there's the application preparation and submission. We work closely with your employer, also with the visa applicant, to ensure that all the necessary documentation is prepared in a timely manner. We also, when it comes to skill in demand visa, we can take care of the labour market testing aspect. And obviously, we aim for all our applications, whether it be a nomination or a visa application, to be a decision-ready application. So what does a decision-ready application mean? That the next time we hear from the case officer, it's about your approval. It's not about please provide more information. Saying that though, obviously some processing times for certain visas have blown out a bit. So periodically, every 3 months actually, our coordinators will be in touch either with the visa applicant or your employer to refresh whatever documentation required. So we're always up to date. So from the employer, it's mostly BAS statements and financial reports. And from the visa side, it might be health exams, police certificates, and stuff like that. So obviously, post-lodgement monitoring is something that is really important, and that's something that Equestria Immigration does complimentary. So there's no additional cost for that. We'll look after your nomination and visa right up until it's granted. All right, so we did look now at some of the common issues, particularly for those who are holding a TSS visa and looking to transition to permanent residency for the 186. One of the most common issues, particularly those who are on a short-term occupation, so a 2-year visa from the TSS, is unpaid holidays, right? So if you've taken unpaid leave while on a 482 visa, this could be problematic, particularly for those who are on a 2-year short-term visa. I mean, it's not categorically mean that you won't be able to apply for PR within the 2 years. I mean, there are ways we can work around that. And obviously, if we understand the intricacy of your situation, we can provide advice confidentially about that, right? Where it does become an issue, or it is a bit more urgent, is, for example, if you're on a short-term stream, TSS visa, and your occupation was removed or wasn't included in the CSOL, then it becomes pretty urgent that we sort of tackle this issue as early as possible to be able to secure your path as a permanent resident. Now, if you're on a short-term visa, TSS visa, and your occupation has been incorporated in the CSOL, then worst case scenario, you'll have to extend with a skill in demand visa, albeit for 1 year, and then as soon as you're eligible, apply for the 186 visa, right? But in any case, I mean, there are solutions if you've had unpaid holiday leave, depending on your salary. If your salary is higher than the nominated salary when you applied for nomination and your visa, there's a couple of workarounds we can provide. But I would recommend that if you're on a temporary skilled shortage visa, avoid taking any unpaid holiday leave because it could delay your eligibility for permanent residency. So that's just a recommendation that we have. Another issue could be if you've got multiple employers. So obviously when you're on a TSS or skill in demand visa, you are able to change employers. Mobility has become a big thing with the department, and the arrangements now for sponsored employees are a lot more flexible. Obviously, some of the main changes have been that if you hold a TSS or skill in demand visa and your employment has ceased with your sponsor, you are able to, and your sponsor has reported that to the department, from the day that they report that to the department, you can work for another employer in any occupation actually from the next day. You've got 180 days or six months to find a new sponsor in your nominated occupation. So things have become a lot more flexible there. Another issue could be visa condition breach. So if you haven't complied with all your visa conditions, and there are some pretty stringent conditions to a temporary skilled shortage visa and skill in demand visa, you've got to maintain health insurance. You can only work for your sponsor. Potentially, you might have been working on ABN as opposed to being a full-time employee with tax file number. There's a myriad of ways you can breach your temporary skilled shortage visa or skill in demand visa. That's something that you've got to be mindful. And if there's any doubt whatsoever, again, the earlier you confront the issue and seek professional advice, the quicker we can solve the issue. Incorrect pay is another common issue. So your employer hasn't paid your super or has shortchanged you. So obviously that can be corrected in the long term. And the quicker you identify that and bring that to our attention, the quicker we can solve that issue as well, along with your employer. Contractor work. So if you've worked on an ABM as a contractor, look, I mean, it's pretty well documented that obviously when you lodge a nomination for a skill in demand visa or a temporary skilled shortage visa in the past, it's a full-time contract with TFM. The issue may arise sometimes when basically you might be already employed with your sponsor, but you might be employed as a contractor or getting paid with your ABN. Obviously, from the day your visa is granted, then you need to be transferred to an employee and paid by a tax file number as per your contract. Sometimes there's a bit of a lag, right? So obviously your visa is granted today. We call your employer. Congratulations, nomination, visa is granted. Can you please make the candidate full-time employee with tax file number now? Yeah, sure, no worries. Sometimes that might take 1 week or 2 weeks, right? And that can certainly be an issue if you're applying for 186 TRT, particularly if you're on a short-term stream and your visa is only for 2 years. So that's something definitely you've got to be mindful for. And the reality of the matter is that even if you're on ABN and you've applied for a temporary skilled shortage visa or a skill in demand visa, a lot of the time when we submit a contract, full-time contract, as part of the nomination, if the employee is getting paid via ABN, then the contract actually is subject to 482 visa approval. So what that means is that your conditions as per the contract will commence when your 482 visa is approved. So if that's the case, and I can tell you from a lot of our clients that's the case, probably 50-50, you just got to ensure that your employer converts you to an employee, tax file number and super, really from the time your visa is granted. Late start, so if you began working much later than the 482 visa approval, this could be for a number of reasons, but particularly if it's an offshore application. So if you've applied from overseas for your 482 visa, obviously the visa is granted and then you need to take some time to make arrangements to come to Australia. So often it could be a 1 week lag, it could be a 2 week lag, it could be a 3 week lag. And that's pretty normal. Again, the issue is, if you're on a medium-term visa for 3 or 4 years, it doesn't really matter. Obviously, as soon as you've accumulated 2 years, you can apply for PR. But when you're on a 2-year visa and you've applied offshore, this could be an issue. So, what's the recommendation there? Obviously, be ready to go if you've applied offshore and come and work as close to as possible as your 482 approval date. English score as well. So obviously the English score for 186 is a little bit higher than skill and demand visa. So as we said, for the skill and demand visa, it's 5 in each component, at least 5 in each component. Whereas for the 186 visa, it's 6 in each component, right? And even your dependents need to have functional English. So that's 4.5. But especially for functional English, whereas competent English is 6 in each band, is your English test score is valid for 3 years. So even if you've done a test 2.5 years ago, if you've got the required score, you can use the same certificate. However, if you're a dependent and you need to have functional English is only relevant for 1 year, right? So if you've achieved a score of functional English, which is 4.5 in IELTS, 1.5 years ago, and even if you had in that test score, you achieved superior English 8.0 in each band, it's not going to be valid. So unless you've done the test within 1 year of the time that you applied for the visa. So an English for the 186 visa, whether it be TRT or direct English or direct entry, is a time of application requirement, right? So very important there. And sometimes this could be an issue that arises. So things to take also into consideration is processing times, particularly for the 186 TRT and direct entry. We're finding that processing times blown out significantly. We could be looking at now anywhere between 9 to 17, 18 months, right? There are priority processing for certain industries and occupations. That depends on what's going on in the general economy at any given time. At the moment, there's a focus, I guess, and a focus on building and construction. So any occupations, carpenters, painters, decorators, construction managers, floor and wall tilers, they'll be processed pretty quickly. Also, teachers, healthcare workers, so social workers, community workers, anything to do with the healthcare industry. But anything else aside from that, I'm afraid there is a bit of a long processing time. That can change in the future, but at the moment, depending on your occupation, if you don't fall under the categories that we mentioned a little bit earlier, then the processing time's unfortunately blown out. And it leads us to our next point, which we touched on earlier. So we do obviously quarterly audit on both nominations and visa applications. So every 3 or 4 months, every 4 months, we'll be in touch with your employer and yourself and request any documentation that we seem fit. And again, this is to make sure that your application is compliant and also up to date, because if we receive a request for further information from the case officer, you could potentially then go at the back of the queue, and that could furthermore blow out the already exhausted processing time. So again, that's a very important to note. And again, that's a post-monitoring service that we're happy to do for our clients, because the earlier our clients receive their grant notification, the happier they are. And the happier they are, they'll tell their friends about us, and we're all happy. So that's the idea. Now, here's some frequently asked questions that our team has sort of come up with. So what happens in the case where you've had multiple employers? So eligibility to apply for TRT with multiple employers. Well, I mean, similar thing applies. So obviously you're able to change employers, but when you do change employers, to begin working and then counting time towards your TRT work experience requirement, the nomination from your previous employer must be approved, right? So if you're working for company XYZ, you've been working for them for 1.5 years, so you're 6 months short of fulfilling the eligibility requirement for the 186. For whatever reason, you cease employment, another company comes along, does a nomination transfer, that's approved. Then you work for your new sponsor for 6 months, right? And then the accumulative 2 years comes into effect. So you've worked for 18 months for company ABC, then you've worked after your nomination was approved, your nomination transfer was approved for 6 months for BCA. Then once you've fulfilled the 2-year requirement, 6 months after working for your new sponsor, you're able to transition to TRT, right? So obviously the English requirement, so we touched on that a little bit earlier as well. So 6.0 or IELTS or equivalent. Test needs to be within the last 3 years. There are some exemptions, passport, UK, Ireland, US, also New Zealand. However, dependents also need to have functional English, which is 4.5 in IELTS or equivalent. As we noted before, that test needs to be valid, needs to have be done within 1 year of time of application. There are some further exemptions there as well if you've studied for functional English. So if you've studied 3 years at higher education, and that also includes diplomas and advanced diplomas. Cumulative, if you've studied for 3 years, then you can be exempt from the functional English requirement as a dependent. There's also the high income threshold. If your income is higher than the income fair work threshold, then you can be exempt from the English requirement. So obviously you can include family members, as we discussed earlier, without them having a subclass 482 visa. You still will need to demonstrate the genuineness of your relationship. You'll still need to demonstrate that you've cohabited for 12 months. If not, you can register your relationship unless you're in WA, where registered relationship certificate is not applicable. Otherwise, anywhere in Australia, irrespective if you've lived with your partner for 12 months, if you're holding a student visa as a dependent and your partner is holding a 482 and about to apply for a 186, you can do a combined application. You just need to obviously prove the genuineness of your relationship and show all the 4 pillars, which are financial factors, social factors, also household factors, and genuine commitment. So it's like doing a mini partner visa, but the key takeaway here is that irrespective of which visa you hold as a candidate dependent applicant, you are able to do a combined application with the primary applicant as long as you can satisfy the de facto relationship criteria. All right, guys, so that sort of wraps it up for today's webinar. We do have some time up our sleeve, so I'm happy to take some questions from the audience. Feel free to raise your hand and Shini will allow you to ask whichever questions that you may have. So over to you, folks.
Hello, Bill.
Yes.
I've got a quick question about the contract on the 482 visa. I know there's not many things that you can change, like the salary, because it's part of the requirements of the visa itself. But my question is the conditions of the contract once the visa has started. I mean, if there's any we can do, and if it's possible, what kind of changes done?
Well, thanks for your question. So, well, first and foremost, I mean, the salary can actually definitely change. That's one of the things that most definitely can change. Obviously, it can go, but it can't go down, right? So if you're being sponsored and a nominated salary is 75,000, and for whatever reason your employer rewards you, gives you a pat on the back and says, great work, we're actually increasing your salary, or performs a review and they increase your salary, there's no issue there whatsoever, right? The main thing is, I mean, depending on what terms and conditions you're referring to, but you need to remain employed in the occupation you were nominated for the duration of your 482 visa. So you can't work in a different occupation. If you are to work in a different occupation, then there needs to be a separate or new nomination, right? And then the clock obviously will start again from approval there. So I mean, can you be more specific in terms of terms and conditions? I mean, it needs to be a 38-hour week. It's a full-time employment. Depending on industry, there might be some concessions there, but typically speaking, it's a full-time employment with 37 and a half or 38 hours. Pay can go up, can't go down, or needs to remain at least the nominated salary in the nomination application or in the initial contract that was submitted with the nomination. Can you just be a bit more specific about terms and conditions which could change?
Yeah, no, that was exactly what I meant, like about hours and basically those kind of conditions. So no, that's like basic full-time conditions, right? That's what it needs to be followed.
Yeah, correct. Yeah, full-time. Yeah, because otherwise, I mean, if you're not working full-time, obviously you won't be able to fulfill the requirements for the 186. It's also a breach, so you need to be working full-time hours. I mean, some industries that could be 35 hours, but that would be dictated by an award or an enterprise agreement. But if none of that applies, then it needs to be full-time employment, 37 and a half or 38 hours per week. As I said, your pay can increase, but it just can't decrease. And that's that's the situation with the terms and conditions of the contract.
Thanks, Bill. That was all from me.
Thank you.
My occupation is the Disability Services Officer. I checked that this occupation has been removed from the new list. In this case, I'm still, if I understanding well, I'm still can apply for the TRT 186.
Yeah, correct. You can. Obviously, you just got to be mindful of some of those common issues that we looked at in the earlier slides, right?
Yeah.
Because you won't have the luxury of extending or applying for a skill in demand visa.
Yep.
So you haven't had any leave without pay or any unpaid holiday leave, and provided you've nominated salary each year for the 2 years of your temporary skilled shortage visa, then yeah, a couple of days before your current TSS visa expires, you can be nominated for the 186 TRT visa. No issue whatsoever.
All right. Thank you so much. That was my question. Thank you.
You're welcome.
I've just heard around from people speaking to other lawyers' core skills list for the 482 visa that they reckon chefing might not be on there for much longer, or it's looking like it might not hold out as an option. Do you think that's sort of true, or is it sort of hard to say?
Look, I mean, that's pure speculation. I can't see that happening, to be honest, right? The only way they could remove, chef from the CSOL, industry would be up in arms. The only thing I can see potentially happening, but I don't think so, is we don't really have much information about the stream, which is the third stream. So we know about which is in the form that we have at the moment. We know about the specialist stream, where you need to be earning more than 135,000, irrespective of what your occupation is. So the only thing I wouldn't imagine that there wouldn't be the opportunity for restaurants to sponsor chefs. The industry will fall apart. What could happen, which I don't think so, I think chef is pretty much safe as houses, but what could happen in the worst case scenario is that there's an industry labour agreement, and basically chefs would have to go through the labour agreement stream. And, that would have some pros and cons. But again, we have seen restaurant managers taken off the list. Whether cooks and chefs will be taken off the list, I believe that would be highly unlikely.
If you'd already started the process, it wouldn't matter, right? If it got removed, say you were a year into the 482
Well,
visa.
no, it doesn't. It's similar to, I think it was Marlon, the previous guy. So basically, Marlon's on a TSS visa with the Occupation Disability Services Officer.
Yeah.
Now that's been omitted from the CSOL, and we've got restaurant managers as well on our books as clients. But yeah, even though newer applicants won't be able to apply for a temporary visa to be sponsored as a disability services officer or a restaurant manager, existing TSS visa holders in either of those two occupations have the ability to apply for 186 TRT. So there's no particular list for the 186 TRT. That's the key difference. It's a bit of a legal sort of loophole, but there's no occupation list specified for the 186 TRT, right? So that's why, even though disability officers and restaurant managers are off the CSOL, because they've got a valid TSS visa, and if they fulfil the requirements, they're able to be nominated for TRT. And the same would apply for chefs if that was the case. But honestly, I can't see chefs coming off the list. Worst case scenario, they might be incorporated in some sort of labour agreement. But if anything, I think restaurant managers will come back on a list before chefs go off the list.
Okay.
Thanks for your question, Keith.
No worries. Cheers.
Cheers.
Thank you. Thank you, Bill, for this webinar. Thank you also for your team. My question is, if I'm holding a 482 visa, can I jump to 186 before the 2 years, to complete those 2 years?
You can, but I imagine you're referring to the 186 direct entry?
Yes.
Yeah, absolutely. If you fulfill the requirements, so we'll do a quick sort of recap of the 186 direct entry requirements. So you need to have a positive skills assessment in your nominated occupation. You need to be able to demonstrate 3 years employment post skill date or post relevant qualification experience. So, and obviously English requirements, 6 in each band. So, and if your employer is prepared to nominate, if you can fulfill those eligibility requirements and your employer is prepared to nominate you for direct entry, then yeah, of course, there's no issue whatsoever, Seb.
Right. Thank you very much.
You're welcome.
Oh, test. Hello.
Yeah, hi, Briscoe.
Oh, hi, Bill. How you going?
Good, thanks, mate. Yourself?
Yeah, not bad. So I was just wondering, currently on 482 CSS short streams like graphic designer. I'm just wondering if I can take in any freelancing job outside of ABN.
Yeah, no, actually, it's not allowed, right? Because one of the conditions of your 482 visa is that you can only work for your sponsor and in the nominated occupation. So taking on freelance work with ABN would be in breach of your 482 visa. And that, could potentially obviously lead to cancellation of your 482 visa. So definitely wouldn't be recommended. I understand the nature of graphic design and marketing specialists, but the reality is that being so close to being able to transition to PR, and I believe graphic design is one of those occupations that were omitted from the CSOL as well, which haven't been included in the consolidated skilled occupation list. So the reality is that you'll have one bite at the cherry to be able to transition to PR through the 186 TRT, and it wouldn't be advised to be breaching your visa condition because, like I said, you'll only get one shot at the title through this pathway. So, I'd be very careful. I understand that there could be some opportunities that you might be missing out in, but the reality is as soon as you're a permanent resident, that's when you'll become a free agent and you can continue working for your employer, but you can also pick up any other work, as much work as you want without it impacting your PR. By that stage, you'll be pathway to citizenship. So need any further clarification, Briscoe?
Yeah, I think that pretty much answered my question. Thank you.
All right, you're welcome.
Cheers.
Look, I'd like to thank everyone for their participation in today's webinar. I hope you found it helpful and informative. Again, I'd like to stress that all the information here provided today is of a general nature. So if you would like some personalised advice based on the intricacies of your individual circumstances, then you'll be able to, make a consultation with myself or our other registered migration agents. Would be able to obviously identify any pitfalls early on to be able to overcome them and put you back on your path to PR. May not be any issues whatsoever, but you might just want to do a sanity check or even explore other options as well. So everyone will receive some communication after today's webinar. There'll be an invitation to book a consultation with a discount, 25% discount. We'll also share some of the links we talked about today. So please keep yourselves informed, stay up to date. Follow us on our social channels, so Facebook, Instagram, also LinkedIn. And also please sign up for our newsletter. There's some really valuable information that our team is producing on a weekly basis. I hope everyone has a wonderful evening. All the best to you all. Look forward to catching up soon. Thanks, Ginny and team. We'll see you guys soon.